We don't have to tell you to speak into the microphone. You know how to use it.
It's all, we're all good.
Okay, terrific. Thank you for being with us, and tell us what the issue is, please.
All right. Of course, I'm requesting the county commission to rescind this county commission to rescind the sanctions placed on me by your previous county commissioners. To start off, the previous county commissioners never let me come before you, before county commission. So whether you remove the sanctions or not, you've already proven to me, especially the 4 new commissioners, that you're serious about fixing some things that the previous county commissioners allowed to happen without public input. So this is paramount right from day one. I mean, you guys haven't been sitting here that long. So, Mr. Pasha, you've been here a little bit longer, but this is paramount. So if you don't really understand what happened, I'd like to give just a short presentation of what the sanctions were about. So I challenged, since 2007, my assessment on my property. Since that time, the rules, regulations, and even the procedures have drastically changed, even after sanctions were put on me, because the previous county commission thought that it would destroy their funding, because that's where most of their money comes from, is assessments and what is brought from the assessments. Since 2007, I've actually gotten through legislation and through the tax, property assessment tax, is that you can present to a administrative law judge to challenge your assessments. You don't have to go to the Board of Review and Equalization, and you don't have to go to the circuit court, which would both be in violation of conflict of interest, because here you're making decisions on assessments when you're actually receiving the money. It's pretty simple, but they were pretty mad about that. So one of the other challenges was I challenged the school board levy. Of course, that never really went to court because Judge Sanders said, and this is in the documents at the West Virginia Supreme Court, that his dog ate his paperwork. This is real. And so since then, through legislation, and I think y'all already know about this, that no one can bring a special election to do such as levies and that type of stuff. And I was paramount in bringing this to the legislation, and now they can't do it. The school board was bringing these levies, were not properly presented. They were not properly notified. The public was not told where the money was going, how it was to be used, or anything else. It was just like, oh, well, we're going to put this $15 million a year levy on you and you're going to pay it. It wasn't right. So the assessments and the levies, they're already taken care of. So I don't need to challenge the county for those types of things. Matter of fact, I already challenged my assessment this year. It was reduced over $60,000 in assessment value. And you guys never even heard about it. Isn't that amazing? Because I'm not here to attack you. I'm challenging the government within their own laws. So one of the other key points that really upset the previous county commission is 732 and 732A, where I challenged that the county commission previous moved here from the courthouse and didn't display the bulletin boards or the American or state flag. I challenged that clear to the U.S. Supreme Court. They affirmed that that needed to be done. They were not very happy. And in retribution to that, then sanctions were put on to me through an appeal of my assessment, which should never have been allowed, which they attempted before and it was thrown out. So I'm asking you to understand that within the sanctions, it says that this was not to hinder me in any way to challenge legitimate challenges. All my challenges were legitimate. All the cases that I have, I had to put up a bond. And if I'd done anything wrong, plus the fact that the judge has the responsibility under Rule 11 of TCRs, that to make sure it's legitimate before he brings it forth. I have with me in my packet all 8 bond checks given back to me by the court, proving I didn't do anything wrong. And I didn't cash them because I want everybody to know that I still have the original checks that were sent back, proving I didn't do anything wrong. So I'm asking you as the commission to rescind what was done before. And even with it being done, I found other avenues and got most of it done. I'm not here to hurt you. I'm here to help you. And I think that during our campaigning together, that all of our platforms were closer. There was more things that we were in agreement with than there were differences. And I'm here to help you, not hinder you. But sanctions still hinder me from helping you. So that's what I'm presenting to you. I have not sued anyone. I've appealed. It has not cost you, the commission, the prosecution, the state, one single penny. Well, how do I know that? Because I have a FOIA that says that. They claim that this was costing them money and all this. No, these are challenges. It didn't cost you anything. I have made our county and state better for the things that I've done. And I've asked nothing of anyone else. So I plead to you to take something away that should never have occurred to begin with. And I still stand strong. But even if you decide not to remove the sanctions, I'm still here to help. I think I'll be hindered. But I think this is a great opportunity for you to make a decision, whether you're going to do your job with what somebody else has made a decision that's on your back. So.
Thank you, Mr. Tabb. I have 3 questions for our council. We can get into discussion. One, could you comment on Mr. Tabb's assertion that he's not sued anyone? 2, could you comment on the assertion that this has not cost us a penny? And then 3, the one legal question, can the county commission remove sanctions? And a related question, there's a draft motion to require the county prosecuting attorney to do something. Can the county commission legally require the county prosecuting attorney to do something? Would be my 3rd question, kind of related to the one prior to that.
Thank you. That was several, the same, I had the exact same questions. Thank you.
Copy of the state Supreme Court's memorandum decision that imposes sanctions on Mr. Tabb. The state Supreme Court fully adopted the order that was issued by the Jefferson County Circuit Court Judge
Mr. Cochran, would you mind repeating that with the mic?
Sure. I've just handed you a copy of the memorandum decision from the West Virginia Supreme Court of Appeals, dated March 23rd, 2018. And in that decision, the state Supreme Court wholly upheld the decision of the Circuit Court of Jefferson County, Judge David Sanders. I have to lay a little background here to answer your questions, I think.
Okay.
If you review the memorandum decision and you review the Supreme Court or the Circuit Court decision that's attached to the back of it, which again, the Supreme Court wholly adopted and incorporated into its order. Actually, I've never seen that done before. But this particular decision arose from, it did arise from the context of a Board of Review case that Mr. Tabb really walked out of and then challenged later. However, if you look at the actual decision, Mr. Tabb's rights to file a lawsuit are not impeded at all. Except for if he wants to file a lawsuit, before he files it, he has to go to the judge of the court and get that judge's, I guess you would say, review of the lawsuit before he can file it. And I think that would have to do with whether or not the suit is frivolous. Or in the alternative, he can bypass that step and he could hire an attorney to file it. And the attorney, as all attorneys do when they file a lawsuit, their signature on that bottom line says, because of the rules of that attorneys work under, it says that the attorney is not filing this suit to be frivolous or just for purposes of harassment. So the underlying point that is really the major point is Mr. Tabb can file a lawsuit right now. He's not impeded in doing that as long as the judge can look at it first and decide it's not frivolous. Now, that would be the same sort of decision a judge would make later on in the case after it got filed. So a judge, if you go and file a lawsuit without having that sort of determination up front, then later on, if the lawyers in the case on the other side believe it's frivolous, they'll ask a judge to throw it out. So that's not a deprivation of anyone's rights. It's just making that call up front. Now, why was that the relief? Okay, if you look at the case, the circuit court case underlying the Supreme Court case, and you would have to turn to the end of the Supreme Court case, I think is on page 7. And then you turn and you see an order granting motion for sanctions. Mr. Tabb, do you have a copy of this? I'm sure you do.
Oh, I have it in my head, yes, sir.
All right, because I have a copy here. I'll give to you if you want.
That's fine.
Okay. There's a table. And in that table, the circuit court went through a whole bunch of cases that Mr. Tabb had filed. And I would say the modus operandi of Mr. Tabb in filing many of these cases was to file the case and then go through and move to recuse various parties in the case. For example, one of his most common motions was to recuse the judges and sometimes the prosecutor, because he said that the judges couldn't sit over his cases because the county commission provides them with office space. We're required to provide them with office space by the law. Okay. But he says that that is a conflict of interest. Same thing with the prosecutor. If you look down through these, this table of cases, you can see, and of course, these are just little tiny one sentence summaries of a case that might have lasted for a year or two. Okay, so, but we could look through this multi-page table if you want. But generally, he's moving to recuse and disqualify for various reasons. Again, like quite often the office space issue, sometimes claiming that there were prejudices, sometimes because there was a hearing that was continued and the judge wouldn't speak to him ex parte without the other side being there. Sometimes because he didn't believe the lawyers presented the evidence properly. Sometimes because like for instance, in 13C432, because the court had recused itself based on one of Mr. Tabb's prior motions. A judge from out of the area, Judge Fry, was appointed. And the summary is basically that Mr. Tabb stated that he called Judge Fry twice and left 2 messages, but Judge Fry didn't call him back. He then filed a complaint with the Judicial Investigation Committee. The West Virginia Supreme Court of Appeals did not disqualify Judge Fry. Also, Judge Fry's alleged continuance or cancellation of a hearing scheduled for June 16th, and Judge Fry, after he continued the hearing, didn't appear at that canceled hearing. So in that complaint, Mr. Tabb filed a missing persons request with the West Virginia State Police for Judge Fry. And requesting their assistance in locating Judge Fry and notifying the prosecuting attorney's office, Sheriff's Department, West Virginia Supreme Court, Jefferson County Circuit Court, Jefferson County Commission, Governor Tomlin, and Senator Manchin. There's lots of things, but ultimately, the court, the circuit court held, and again, that Mr. Tabb could file lawsuits, and he still can. He can file a lawsuit today, but he just has to go to the judge and say, Judge, this is the lawsuit I'm going to file, and the judge has to look at it and determine that, okay, that's a valid lawsuit, you can file it. So the court basically held a variety of things. I'm not going to go over everything, but the court held, it's become apparent that Tabb has engaged in a serious wholesale pattern of wrongdoing in this and numerous other cases that negatively impact the administration of justice. The court finds no mitigating circumstances that explain Tabb's incessant quest to litigate against the county, its employees, and other officials. Based on the evidence and arguments presented in the motion for sanction and Tabb's own statements before the commission and elsewhere, the court finds it is unlikely that Tabb will stop or even slow his litigation and other complaints absent active intervention by the court. Therefore, a lesser sanction is unavailable. And the court looked at some other cases. I've got copies of a couple of other cases here. This is not the only time that this has happened in West Virginia. There are other people that courts have given these sorts of sanctions against, people who would just kept filing lawsuits that were unmerited and kept filing them, and courts took the same path with them. So Mr. Tabb is not unique in that respect. It's happened to other people. And so the court basically fashioned the relief that said, hey, you can file a lawsuit. You just got to show it to a judge, or you got to go hire a lawyer who's got to sign his name at the end of the lawsuit that says this is not frivolous. You got to understand that before we can talk about the other.
Okay, that was a very lengthy answer to my first question. I had two more, and I'll open it up to everybody else who might have
Okay.
questions. The other two were, there was an assertion this does not cost the county a penny. Is that accurate?
I do not believe it's accurate. I am not paid like a private civil attorney would be paid. You go into a normal lawyer's office that's just a regular private practice lawyer, and you hire them. And unless it's some kind of contingency case, they're going to say, sure, I'll work for you for this much an hour, right? And many of us have experienced that. I don't bill like that. I just have a salary from the county. My time, I've worked here maybe 10 years. So the first several years, I spent a great deal of my time litigating against Mr. Tabb. I will say he did not win any cases. I will say, ultimately it ended up with the court holding that he made frivolous allegations, and he did that with I read what the court said. So,
If you're not
my time,
billing per hour, can you estimate how much time? I mean, I know you're not tracking by the minute here,
Yeah.
but what roughly?
I mean, there were times that I spent my entire day, my entire week, all the time working on Mr. Tabb's numerous cases. He filed a lot of them. There were times that I didn't work on him as well, but I mean, it's a guess. It's just an estimate. I would say I probably spent 25% of my time the first few years litigating against Mr. Tabb, if you look at it in the conglomerate. So I think it is it doesn't tell the whole story to say it didn't cost the county anything, because you pay me to do work, and what I had to do in those cases is defend against frivolous lawsuits that were ultimately thrown out.
Okay, well, we pay you considerable salary, so 25% is valuable to the county. We can get into that later. The last question I had was the legality of the county commission removing the sanctions. Can the county commission remove sanctions? And related question, can we require the county prosecuting attorney to do something?
The court imposed the sanctions. You don't have authority over the West Virginia Supreme Court to undo those sanctions. I think it is questionable for you to say that you could force the prosecutor to do this. I don't believe that you can, because we have a duty to not file frivolous lawsuits ourselves. And the West Virginia Supreme Court has already ruled what it ruled. And I think it would be questionable for us to try to undo that ruling, because it is a clear ruling based on evidence. Now, nothing stops Mr. Tabb from seeking that on his own. But
So Mr. Tabb could ask the state Supreme Court to release these sanctions.
I suppose he could.
Okay.
He's still under the order that he has to go to the court and all that
Yeah.
stuff. that has to-
Because I didn't think we had the authority to overturn a judge's decision.
No, you
Okay.
do not have any authority to do that.
Okay. I didn't think so, but I wanted to hear that from you.
Other questions from the commission?
Actually, I think you've covered it pretty well.
Covered mine.
Do I have any rebuttal?
Yeah, please go ahead.
So, on the case that Mr. Cochran was talking about, and I don't want to get into a fight on this thing as being a court issue.
Okay.
The county commission brought that sanctions against me. So whenever a sanction is brought, one who brought it can take it away. So you can ask the previous county commission, you personally did not do this. The other issue on Mr. Cochran told partial truth is that Mr. Cochran and the county commission had to go out to the middle part of West Virginia in front of Judge Fry. Judge Fry did not have a problem with me asking of his whereabouts and concern. We had a lot of things going on at that point in time. And he apologized for not responding to what was already in his order. And he apologized for that. But at the same time, the county commission did not do what Judge Fry told him to do. So he ordered, and this is in the records, Judge Fry ordered the county commission to include Mr. Cochran to come to Moorfield and make sure they brought their toothbrushes, because they did not do what they were supposed to do. You have a bulletin board and flags out here on this facility because of one reason. Because Judge Fry said it was going to happen and gave Mr. Cochran and the county commissioners an opportunity after he received a phone call from Charleston when he was getting ready to make a decision, and got a phone call from Charleston not to do what he looked like he was going to do. In other words, there was communications from the courtroom right straight to Charleston. I don't know who exactly it was, but he received a phone call. So he gave the county commission 30 days to correct what he had already ordered, and they were in violation of. So I consider that a win, and most all the other ones, I got my assessments reduced, even going to the West Virginia Supreme Court, where the Supreme Court actually, before Mr. Cochran was here, basically handed that person, you don't need to say the names, but she was there unprepared, and the West Virginia Supreme Court, in short, basically told her that do not come before this court unprepared ever again. I know, I was there. I've been there several times. I came before you asking you to undo what the previous commissioners. I'm not here to retry what happened. This sanction has been used by other boards and stuff where you don't have a judge or required to have a judge to say, which everybody else in this room without sanctions has to bring before a board. Mainly what I've done is the insurance commission. And they said, oh, Mr. Tabb, you didn't get a court relief. Well, nobody else has to. Nobody. And the position that Mr. Cochran and some of the other people have placed on me, that he kept on saying that I can sue people. I didn't sue anybody. I appealed a decision. And I mean, I have these checks and stuff right here. These are the bonds that I paid, and they paid me back. And if it cost within the bond, it's very clear that if I cost anybody any money, this money would be used towards that. That's what bonds are all about.
Do we have an estimate of how much the staff time costs, the staff time that was devoted to this? I heard an estimate of 25% of time, but do we have an estimate in terms of dollars?
So I think in order to do that, to be clear, you're saying 25% of your time or any other staff?
Do we have paralegals working on
Yes,
this?
my paralegal, sometimes other counsel.
Did we ever hire outside counsel?
I believe that we did hire an outside counsel, at least one time, because Mr. Tabb accused me of wrongdoing and I could not represent.
Did
that
he,
case.
did he file a missing persons report on you?
He did not.
Okay, thank you.
He said that I violated a rule because there was an issue where Mr. Tabb had improperly served, as I recall, the original documents. And as I recall, we had moved to dismiss it because he had not properly served it. There was a record in the file as to where he had signed a document saying how he had served it, but that was improper. And I argued to the court that he had improperly served it. And I believe that Mr. Tabb said that I could not do that because I needed to call witnesses. And I did not need to call witnesses because it was just right in the court file and on the judge's desk and he could look at it. So that was the impropriety of which I was accused in that case.
Well, I know we're not tracking, to the dollar amount, how much was spent because you're on a salary basis. But we're trying to estimate time. I'm wondering, does our staff have an estimate of how much time was used by different staffers on this and what that would roughly cost?
Yeah, and there were, I would say that my salary was less back then.
Sure.
Then
How much, as a percentage, was your paralegal spending on it?
Right.
Did they spend it at an annual rate?
Out of 2080.
I mean, I don't know, at least as much time as me.
If we say 25%?
Okay.
And then additional counsel?
I don't have that number in front of me, but we hired a private counsel to represent us in at least one.
I think it's fair to say, though, you spent a significant amount of time that took away your time from more serious issues that were facing the county than several frivolous lawsuits. I do have a question for Mr. Tabb. Did you ever put a $13 million lien on the courthouse and why?
That was because of the ambulance fee.
And you put a $13 million lien on the courthouse because of an ambulance fee?
I did.
Okay.
And how did that result?
I don't know.
Okay. So, since that question was asked, 2 years later, Judge Hammer, said that it didn't appear to be, we had some problems with the court system at that point in time. We really didn't have a judge in the county. We had some deaths and some other problems. So for 2 years, it sat, filed at the courthouse properly, which no one had a problem with. And it was structured in a way that the community never got to vote on that ambulance fee.
If you won $13 million, what were you going to do with the $13 million?
Give it back to the public.
Okay.
It wasn't for
So-
me personally.
Just kind of back of the napkin math, we're looking at about $65,000 a year.
A year, 3
And then
years?
for 5 years, 10 years?
I don't know.
Okay.
This was 2018, so,
And your table in there. included-
probably 3 years, probably 3 years. Yeah.
65K a year for a few years, right? I mean, it's an estimate. We don't charge by the hour.
Yeah.
You're
It-
salaried, but that's important information that I wanted in the public
Yeah.
discourse. So I appreciate
And
that.
and
Thank you.
again, it is truly, as the administrator said, back of the napkin, because I have.
I understand.
measured.
Mhm.
Understand. There was a draft motion to require the county prosecuting attorney to do something. council is advised that's not legal. Is there a motion on the floor? from
Can
anyone in the
I
commission?
finish up? Because he said that this cost X amount of dollars. So,
We're an
it-
hour over, so we can, if we can wrap with this comment, and we're
Yes.
gonna move on. Go ahead, please.
so in the ambulance fee, the judge dismissed it. Mr. Cochran asked for $10,000 for his fees. So his fees, he's only talking about $10,000. And this took more time than any of those other cases. And then when the judge allowed me to have a jury trial, Mr. Cochran, would you like to tell the county commission what your response was to that?
You can direct your questions to the commission.
Okay.
Yeah.
Can you ask him to,
So we're like an hour over, but but if you want to move on, I mean, it's something else, that's fine.
so we had a jury trial scheduled on
Mhm.
this whole issue for $10,000. And advised by whoever, I'm assuming that he took the advisory from the previous county commission, they decided not to have a jury trial. So right there is the point that they could have gained, if I was wrong, if I did anything wrong through a jury trial, you could have received $10,000. So where would that money have gone? But they chose not to. So again, I'm disputing again what there was any amount of charges when you had a judge say, we're going to have a jury trial on $10,000. In the commission, of course, Mr. Cochran can't do this on his own personally, by instructions of the county commission at that time, chose not to. Yet we still have the ambulance fee in place. And I still use that today to show to the ambulance authority that I don't have to pay that. So, but again, it comes down to it. Are you going to use what somebody else did that I still think is frivolous of putting sanctions on me? You have the constitutional right and or the responsibility. And what this paperwork says is not true. There was another case. I took and paid an attorney $6,000. The judge allowed the attorney to leave the case, not pay me any money back. And this says only to start a case. And the judge still denied me and threw me out because I didn't have an attorney. So this is the point that I can bring forth. If y'all want me to bring it, I'll bring it. But I'm trying to give y'all an opportunity as a fresh start. So you're either a part of the solution or a part of the problem.
Okay.
Thank you.
Appreciate the offer, sir. My answer to you is respectfully no. Do we have a motion on the floor from any of the commissioners? I don't hear one, so we're going to move on to the next agenda item. We are on page 71. Mr. David Bound, do you have a presentation?
Thank you, Mr. Tabb.
Thank you.